Hello, I'm Christine O'Neill QC and I am a partner in Brodies Government Regulation and Competition team. I'm joined by my colleague Kirsten Burke, who is an associate in the GRC team as well.
Hello everyone.
Kirsten, there's been a lot in the news recently because of the announcements made by the Prime Minister Boris Johnson and Scotland's First Minister Nicola Sturgeon about public inquiries, and in particular the potential for a public inquiry and possibly two public inquiries into the COVID pandemic. The purpose of this session is to answer some of the regular questions we're asked about public inquiries, and also to explain a little bit about how you can become involved in a public inquiry if you have an interest in the inquiry's work. Kirsten, we might as well just kick off by asking you the question, what is a public inquiry?
Well, as you say, Christine, it's a term that's been in the news a lot recently, and essentially it's a major investigation which is established by a government minister to investigate an event or events which has caused significant public concern. Recent examples include the Grenfell Tower, the Scottish child abuse and infected blood inquiries. Inquiries can be set up by the UK government or by the Scottish, Welsh or Northern Ireland ministers. And sometimes they can be set up jointly by the different governments working together. A chair is appointed by the minister and an inquiry is funded by the government, but otherwise the process is independent from government. A key point to note is that an inquiry does not result in anyone being found liable in a civil sense. So, for example, an inquiry can't order that compensation is paid, and nor does an inquiry find anyone guilty of a criminal offence, although separate criminal prosecutions or civil claims can arise out of the same events.
So, Kirsten, I suppose some people may be thinking if there can't be civil liability, if there can't be an order for compensation, and if there can't be criminal convictions, what exactly is the point of a public inquiry?
It's a question that's often asked, and unlike court actions, which are normally described as being adversarial in nature, a public inquiry is an inquisitorial process. Its role is to determine principally what happened and why, and who's responsible for what happened. Finally, it will look at what can be done to avoid similar events recurring in the future. An inquiry will issue a report answering these questions and setting out its recommendations for change. This generally happens at the end of the inquiry, but it may be broken down into phases with interim reports and recommendations being made during its course. Christine, the Prime Minister has confirmed that the UK government's COVID inquiry will be established under the Inquiries Act 2005. Can you explain the significance of it being set up in this way?
Yeah, so again, the clue is in the question. Being an inquiry set up under the 2005 Act, it would ordinarily be referred to as a statutory inquiry, and a statutory inquiry has a range of powers that are different from less formal inquiries that might be set up by public bodies to look at particular issues. Some of those powers are, for example, that the chair of the inquiry has got powers to compel organisations to provide documents and other material to help the inquiry with its work. The chair of the inquiry can also require people to come along to the inquiry as witnesses and can force them to give oral evidence at hearings. And the chair can require that where there are oral hearings and witness evidence, those witnesses should give evidence on oath or under affirmation. There's also a presumption with a statutory inquiry that the process will be in public. That's a really core element of public inquiries. It's that open scrutiny of events that's regarded as very, very important. And over recent years, we've seen public inquiries do an awful lot more to make their proceedings accessible to the public, for example, by live streaming online. And then when you get to the end of the inquiry process, there are some peculiarities or specialities about the reporting process, and one of those is that the inquiry needs to give people who might be criticised by the inquiry, it needs to give them warning of that criticism and the opportunity to respond to that criticism and to make representations to the inquiry, a process that's often known as Maxwellisation. So that's a little bit about witnesses and people who may appear at public inquiries. Kirsten, do you want to say a little bit more about what people might want to be thinking about if they want to become involved as participants in inquiries?
Yes, absolutely. For every inquiry, there will be some individuals and organisations who wish to be more involved in the inquiry's process. If this is the case, they can apply to be a core participant in the inquiry. And unlike witnesses, core participants can make opening submissions and closing submissions at the inquiry's hearings. They have access to documents and witness statements which have been submitted to the inquiry before those documents are made public. And they can also obtain a copy of the inquiry's report before it's made public. A core participant may ask questions of witnesses at the inquiry's hearings if the chair grants permission to do so. Now, this is rare, and the inquiries adopt a procedure allowing core participants to submit suggested questions for witnesses, and those questions are then asked by counsel to the inquiry. Moving on to a slightly different issue, the inquiry may invite a party to apply to become a core participant, but cannot force anyone to do so. Equally, not every person or organisation will be granted core participant status that applies. Christine, can you explain how these applications are made?
So the way the applications are dealt with is really within the power of the chair to the inquiry, and they will take the decision about who is or is not allowed to become a core participant in the process. The chair will do that by reference to a number of criteria, and those are things that you would expect. So, for example, whether the proposed core participant has played a key role in relation to the matters that the inquiry is looking at, whether they've got a significant interest in any of the matters that are covered by the work of the inquiry, or indeed whether those individuals or organisations might be, as we've mentioned, subject to criticism by the inquiry. But not everyone who fulfills those criteria will automatically be allowed to be a core participant in an inquiry. And one of the things that the chair has to do is to think about whether it is desirable that any particular applicant is involved as a core participant in the inquiry. And that gives the chair quite a lot of flexibility, and the chair of the inquiry might, for example, publish guidance to prospective applicants about the criteria they will apply when deciding whether or not someone should or shouldn't be a core participant. This arose in the context of the infected blood inquiry, where the chair, Sir Brian Langstaff, was conscious that there might be a very large number of people who could fulfil the general criteria to be core participants, people themselves who'd been infected by hepatitis C or HIV from blood products, and people who were affected, for example, as family members, by such infections. He realised that that would give rise to a potentially very large number of people who were going to be core participants, and so he published separately a protocol giving extra guidance on the kinds of factors that he would look at when deciding whether or not someone was to be a core participant. Just in terms of that kind of guidance, Kirsten, do you want to say a little bit about what we might expect from the COVID inquiries?
Well, I think we can all imagine that the COVID inquiry will raise even greater challenges of scale than the infected blood inquiry. Everyone in the UK will have been impacted to some extent by the government's handling of the pandemic, so it seems very likely that guidance issued by the chair will play a significant role. And it may be, for instance, that commercial organisations and charities will try to become involved through a trade or umbrella body, which then applies for core participant status in the inquiry. It's also worth noting that parties who do not wish to become core participants can still be called as witnesses. So even if an individual or organisation is engaging through a representative body or doesn't wish to engage at all, they can still be called upon to provide evidence to the inquiry.
That's really helpful, Kirsten. In terms of people who do want to become involved in the inquiry, or think indeed they may be called to become involved in the inquiry, what advice would you have for them in terms of preparation?
I think it's key for parties to appreciate that public inquiries are a different beast to litigation. The process itself is very different. The chairman has wide powers to decide how the inquiry is run, albeit within the confines of the Act and the associated rules. The process is very much driven by the inquiry. However, there are a number of things you can do to prepare for engaging with the inquiry, and we've produced a short guide that relates to the steps that can be taken in advance of the COVID inquiry being convened. However, this might also be relevant to parties preparing for other inquiries as well.
That's again really helpful, and I think probably a good place to bring this session to a close. If you do have questions about public inquiries, please do feel free to contact me or Kirsten at brodies.com, and please do look at our website for the guide to preparing for inquiries that Kirsten mentioned. Thank you very much.
Thank you.